Good afternoon, everybody, and welcome to the Sharp-Pritchard webinar on the Planning and Infrastructure Bill. People are joining as we speak, but I think I'll start the seminar off because we have quite a lot to get through. So, my name is Rachel Lee. I'm a Managing Associate in the Sharp-Pritchard's Planning and Parliamentary team, and I have the pleasure of welcoming you today on behalf of the SP Planning team to this webinar event. It cannot have escaped anyone's notice how, since the Labour government, since the elections last year, have high up on their agenda planning reform. And since they came to power last summer, there are lots of things that the government are proposing or have already done in terms of these planning reforms. And the Planning and Infrastructure Bill is a significant piece of legislation that is proposed to go through Parliament to achieve some of those government objectives as set out in their December 24 Plan for Change. So the Planning and Infrastructure Bill first reading was on the 11th of March, where the government introduced the bill into Parliament with a promise that it is to speed up planning decisions and get Britain building again. It's quite an ambitious programme for change that the government have. And these ambitions include delivering 1.5 million homes and deciding 150 nationally significant infrastructure projects. So at its second reading on the 24th of March, Angela Rayner, and this is direct quote, said, "Make no mistake, the bill is to transform the lives of working people and Britain's prospects for years to come." The bill is now at the committee stage. I looked yesterday and there are no dates for the committee stage, but it's expected to be reported back to the House on the 22nd of May. So it is a piece of legislation that is getting a speedy kind of ride through the parliamentary process as it moves towards becoming law. So without further ado, I now have the pleasure of introducing you to the speakers from the team today and the key topics from the bill that we will be discussing. So national infrastructure projects and transport infrastructure, my colleague Amir Thomas, planning decisions, Rebecca Stewart, spatial development strategies and development corporations, Emily Knowles, development and nature recovery, Alastair Lewis and James Goldthorpe, and compulsory purchase, Emily Knowles. We also have a couple of other team members, integral team members who unfortunately are not here today. Bernadette Hillman, who is a planning partner within the team and a key member of our team with lots of years of planning experience on large major development projects, including Bourne Airfield, which I have picked up from the planning publications and press, was in the news yesterday as Homes England, in partnership with others, have got a funding to progress that scheme through a collaborative purchase of the site. And Andrew Swaffer, who's a legal director within our team, who specialises in CPO litigation, the more contentious side of planning and highways law, and also is involved in major regeneration schemes. So we have within our team, we have a vast amount of planning law experience that cover the very aspects of the law that the Planning and Infrastructure Bill is all about. And we intend to take you through on this webinar those key measures proposed in the bill. We would, just from a housekeeping perspective, welcome questions via the chat facility, or towards the end of the webinar, we will have a question and answer session at the very end. So there's quite a lot to get through. So I will now introduce you to Amir, who will deal with the first topic, the INSIPs and transport infrastructure. Thank you, Amir.
Well, thank you very much, Rachel, and good afternoon, everyone. If we skip forward a couple of slides, please, Nona, I'm just going to talk about 4 main points today. First, what is an NSIP? Second, I'm going to give a brief description of the policy background to the bill's proposals. Third, I'm going to talk about what the bill does. And fourth, I'm going to talk about what the bill doesn't do in the context of the proposals set out in one of the government's working papers which preceded publication of the bill. So the first topic then is, what is an NSIP? Well, there's no single overarching definition of what an NSIP is. Section 14 of the Planning Act, which governs the regime, lists 16 types of development which may qualify. NSIP development falls within one of 5 categories, namely energy, transport, water, wastewater, and waste. But not all development within those 5 categories is an NSIP. Being an NSIP is a question of size and scale and capacity. And an advantage of the regime is that it has statutory deadlines for certain stages, giving developers and interested parties a degree of certainty regarding timescale. Consent is granted by the Secretary of State and included in a Development Consent Order, or DCO, which, as a statutory instrument, is as much a piece of legislation as an Act of Parliament. In addition, the Planning Act introduced National Policy Statements, or NPSs, for infrastructure projects of national importance, which fit within those 5 categories I mentioned a moment ago. These documents are the cornerstone of the regime, providing the policy background against which the Secretary of State will decide an application for development consent. The regime gained an early reputation for delivering robust and timely decisions. Up to March 2025, it has consented more than 130 projects, with around 95% of those applied for being approved. However, the system's performance has slowed recently. In 2012, for example, it took around 2.6 years for a project to secure development consent. However, in 2021, it took around 4.2 years. The bill's explanatory notes provide an explanation for the delay, saying that the documents underpinning consents have been getting longer. There's an increased uncertainty that statutory deadlines will be met, with increased litigation causing further delays and introducing additional risks and costs for developers. So if we turn to the next slide, please, I'll provide some background, some policy background to the bill's proposals. So in April 2023, the National Infrastructure Commission, which is an executive agency of the Treasury, published its report on the infrastructure planning system and highlighted issues with out-of-date national policy statements. For example, the report said that in the absence of regular updates to NPSs, older policy positions and aging or obsolete technologies would still apply. And last July, the King's Speech announced infrastructure reforms with the aim to accelerate the delivery of high-quality infrastructure. We turn to the next slide, please. The briefing which accompanied the King's Speech outlined issues with the DCO process and an increase in post-consent legal challenges pursued through judicial review. In respect of the latter, the briefing said that legal challenges have increased since 2021, with 4 successful challenges being made out of the 15 made, prompting 18 applicants to increase the scope and volume of their environmental impact assessments to tens of thousands of pages. And you'll be aware that the previous government appointed Lord Banner to conduct an independent review on JR challenges to the DCO regime in early 2024, and certain of the recommendations made in that report have found themselves in the bill. We'll turn to that in a moment. December last year, the government's Plan for Change announced a bold commitment to decide 150 NSIPs in this parliament, and a couple of months ago, a planning reform white paper streamlining infrastructure planning was published, inviting views on how government could reform the process for consenting NSIPs to streamline that process for critical infrastructure. And if we turn to the next slide, please, We can see how those policy proposals have been translated into the bill. First then, national policy statements. Currently, these are reviewed at the Secretary of State's discretion, either in full or in part when appropriate. While the bill retains this discretion, it is now subject to a condition that a full review must be carried out within 5 years from the date of the relevant provision coming into force, and then every 5 years afterwards, unless there are exceptional circumstances which justify a delay. In addition, the bill introduces an additional parliamentary procedure for making what's called material policy amendments to NPSs, i.e. updates outside of that 5-year cycle. And these amendments would apply where there are legislative changes, relevant court decisions, published government policy, or changes to other documents referred to in the NPS. NPSs are subject to parliamentary scrutiny, and the bill would remove the existing requirement for the Secretary of State to respond to resolutions made by Parliament or recommendations made by Parliamentary Committee which relate to those update documents. And the purpose of this amendment is to streamline the process of dealing with updated NPSs, because the government considers it takes too long to update them presently. For instance, it took more than 4 years to update the energy and the transport NPSs. The next proposal concerns increasing the flexibility of the NSIP regime. And to do so, the bill provides a power for the Secretary of State to direct on a case-by-case basis, and before the submission of a DCO application, that the requirement for development consent is disapplied and an alternative consenting regime could be followed instead. So for instance, the Highways Act 1980 could be used, or the Town and Country Planning Act 1990, or the Transport and Works Act 1992, depending on the type of infrastructure included in the application. And this is based on the flexibility provided in Section 35 of the Planning Act that allows the Secretary of State to direct projects below the NSIP threshold to enter the NSIP regime. And it is considered that this change could be helpful for schemes that sit on the margins of the NSIP thresholds, or where an alternative regime might provide a faster and perhaps more proportionate route to consent. The third point concerns streamlining consultation, and this comprises 3 elements. The first, shorter consultation reports. DCO applicants are required to produce a consultation report as part of their application materials, and the bill amends definition of consultation report so as to reduce the level of detail required. Currently, reports can be lengthy. This reflects, of course, the rounds of consultation that have been undertaken and the feedback provided during those rounds. Instead, the bill proposes a more concise and shorter document. The document will explain the broad approach taken to consultation and also explain how responses have or have not influenced the project. Second, the bill removes the requirement to consult so-called Category 3 persons during the pre-application stage. Provision removes the requirement to consult people who may be impacted by an application, being those likely to have a claim for land compensation. These persons will still have to be notified after an application is accepted. They just won't have to be consulted at pre-application stage. And the purpose here is to reduce the burden on applicants to identify persons before the scope of the project is crystallised. Consulting Category 3 persons is not required under other regimes which provide compulsory purchase powers, such as the Acquisition of Land Act 1981 or the Transport and Works Act 1992. And so this change aligns the Planning Act regime with those regimes. Next, the bill will introduce a duty for statutory consultees and local authorities to have regard for guidance and consultation. The guidance will be targeted so that key consultees identify and narrow areas of disagreement through the pre-application process. There will also be guidance for applicants to ensure they provide consultees with the right level of information to support their role, both on non-statutory engagement in advance of statutory consultation and at the acceptance stage. In addition, and a minor point here, the 2008 Act will be amended by the bill to ensure that examining authorities can award costs in circumstances where an application has been accepted for examination but is withdrawn before the preliminary meeting. I think this is very rare. I'm only aware of this happening on a couple of occasions. So this provision of very limited application, but I mention it just for completeness. And the next change concerns judicial review. And in response to the recommendations made in Lord Banner's independent review, Bill makes provision for the removal of the paper permission stage for judicial reviews of both made development consent orders and also national policy statements. So this will mean there'll be an oral hearing for each of that type of challenge, and then the number of attempts claimants will have to secure permission for a judicial review will be reduced from 3 to 2 in all circumstances. The bill also removes the right to appeal for cases which have been deemed totally without merit at that oral permission stage. So if an application is deemed totally without merit at the oral hearing, that will be the end of its story. I'm next going to turn briefly to what's not included in the bill. The Planning Reform White Paper on streamlining infrastructure planning considered other proposals that have not been included, and I'm just going to touch on 4 of them. Namely, first, extending the use of deemed licenses to other permitting regimes in a similar way to how marine licenses can be deemed granted as part of a DCO under the Planning Act. Second, providing an opportunity for corrections after the DCO is made, or rather after it is made in draft. Now, decisions are published at the same time as the final made order. Corrections are often needed to amend the reference to a plan or another document, or to correct a typo, and there's a 6-week window in which any person can apply to make such a change. The working paper considered whether a draft DCO should be published alongside the Secretary of State's decision letter, the short period then in which applicants could propose minor corrections before final publication of the made order. Third, a single process to amend DCOs. 2008 Act and regulations made under it provide separate procedures for making material and non-material changes to DCOs. The working paper proposed the introduction of a new single change process to speed up and improve this part of the consenting process. Fourth, a new power for the Secretary of State to make statutory guidance across the whole consenting process under the Planning Act 2008 in order to improve the operation of the system with more clarity over expectations for those involved in the consenting process at each stage. Now, I suppose we'll have to wait until the government publishes its response to the responses to the working paper to see whether any of these points are still being considered by the government or whether they've been dropped quickly. Thank you for listening. I'll now hand over to Rebecca, who will consider the next stage. Thank you.
Good afternoon, everyone, and thanks, Emir, for that insightful summary into the changes to the NSIP regime. I'm going to now cover provisions in Part 2, Chapter 1 of the bill, which include reforms to the current system for managing and determining planning applications. And again, I think it's fair to say there's a clear focus on targeting issues of delay. One way in which the government's trying to increase efficiency in the planning process is through changes to the current system for setting planning fees. At the moment, planning fees are set nationally by the Secretary of State and are obviously intended to cover the cost to a local planning authority of processing and determining a planning application. However, the government has identified a significant annual shortfall across the country in respect of the cost to local planning authorities in delivery of development management services. And you'll see on the slide, yep, it's up, the figure of an estimated deficit of £362 million. So the government's position appears to be that this lack of funding means that local planning authorities are not resourced in the ways they need to be to deliver fast and effective planning services, and the bill seeks to address this issue. The bill also takes account of recognised differences across the country in terms of planning costs and deficits. Clause 44 of the bill amends section 303 of the Town and Country Planning Act, introducing a new subsection 5A, which will empower the Secretary of State to sub-delegate their role in determining planning fees to local planning authorities through regulations. This should enable local planning authorities to plug funding gaps according to their own specific level of need. A new subsection 5C also sets various parameters for those regulations to come forward, which will include, for example, the criteria to be applied by local authorities when setting and varying fees, consultation and publication requirements, and a process for notifying the Secretary of State during a local planning authority's process of adopting a new fee structure. The bill sets the expectation that fees are to be set by local planning authorities with a view to ensuring that, so far as possible, they don't exceed the cost of carrying out the planning function in respect of which they're imposed. And there are also provisions to prevent cross-subsidising so that money received from applicants goes towards relevant planning services. There's a list of what the relevant planning functions are in the new subsection 8D, which may be further bolstered by regulations. So at the moment, that would appear to exclude the use of planning fees towards, for example, the cost of local plan making or general planning enforcement, save in respect of determining applications for certificates of lawful existing use or certificates of lawful proposed use or development, which appear to be covered. The bill also provides that the Secretary of State will be able to intervene where they consider that local planning authority charges are disproportionate. The Secretary of State will be able to direct a local planning authority to review its fee or proposed fee, and even set the fee, where the relevant planning authority has either failed to carry out the review in line with legislative requirements, or the Secretary of State considers that the fee remains at an inappropriate level following a review. Next slide, please, Nona. So just quickly, what are the possible implications of this change? I think firstly, it goes without saying that in order to utilise this new cost regime, local authorities are going to need to invest time and resources at the outset to determine appropriate local charging rates, as well as meeting any consultation, publication and notification requirements that are prescribed by regulations to bring a bespoke charging structure into effect. Once over that hurdle, additional financial resources should ideally help local authorities to strengthen their existing planning services, for example, through the recruitment of additional planning officers. One would, of course, certainly hope that this would help to speed up determinations and might even improve the quality of decision making if, for example, individual officers have more time to dedicate to each application, or senior officers are brought in to provide greater oversight. However, you'll see on the screen that I've suggested that perhaps the ability for collection of higher fees offers a longer term rather than an immediate solution to issues of delay. We can surely assume that even after local planning authorities have gone through the process of introducing a new fee structure, the full effect of this will not be felt immediately, as funds will accrue over time with applications and will presumably be spent in line with agreed strategic objectives. As such, I think developers might not see immediate improvements in the planning system, and the speed at which its own application incurring a fee is determined. the prospect of proposed and inconsistent fee hikes might be slightly unpalatable for developers, but they will have the protection of the oversight of the Secretary of State in ensuring that fees are fair and not obstructive to development. There are also the statutory controls that I mentioned within the bill on how local authorities can allocate the funds that they receive. Next slide, please, Nona. So another way that the government's seeking to speed up decision making is through various reforms to the way that planning committees operate. The government's seeking to standardise at a national level the governance procedure for directing whether applications are dealt with under delegated powers or referred to committee for determination. Currently, local planning authorities are clearly able to set their own rules for how different types of applications will be determined. Authorities will usually prescribe which types of decisions are to be made by whom through their constitution, which will include standing orders and terms of reference, and through a scheme of delegation, which might include, for example, that applications can be referred to committee at the request of a ward member. Clause 46 of the bill inserts a new section 319ZZC into the Town and Country Planning Act, which empowers the Secretary of State to make regulations directing which planning functions should be delegated to planning officers and which should be discharged through planning committees and subcommittees. Obviously, as the detail is intended to emerge through regulations, we don't yet know what that scheme of delegation will actually look like. But the government has made clear that its intention is to reduce the number of applications referred to committee for determination. In particular, the government's expressed that it's keen to avoid applications that are compliant with an up-to-date development plan from being sent to committee. This is, they've explained, because of the level of public consultation already involved in the process of local plan making, which obviously sets the parameters for acceptable development in an area. The government sees any further scrutiny of such applications at committee as duplicative and unnecessary. Of course, though, I think it's fair to say each application brings with it its own unique set of circumstances, and I would think we can expect to see that the government will build into its framework the ability for discretionary departures from a prescribed course of action where appropriate. Clause 46 also inserts another snazzily titled 319ZZD, which enables the Secretary of State to prescribe requirements as to the size and composition of planning committees. The government again indicated its intention here that it will be looking to reduce the size of committees to support more focused and controlled debate. Finally, clause 45 of the bill inserts a new section 319ZZA, which provides for the introduction through regulations of mandatory training for planning committee members. Members will be required to obtain a completion certificate to demonstrate that they have undergone relevant training, and members without such a certificate will be prohibited from participating in planning committee decision making. Additionally, local authorities will be required to keep a record of members who have completed this training and publish such a record of certified members on its website. Next slide, please, Nona. So, will these changes have the desired effect of reducing delay? Well, I think if the changes come forward in the shape we anticipate, then there should be an increase in the timeliness of determinations for schemes that comply with the development plan, which can be dealt with under delegated powers. But it is worth noting that it's not clear at the moment what will happen in circumstances where a development plan is out of date. For other schemes, we can probably also expect quicker determinations, with fewer applications vying for a spot on the agenda of planning committee meetings, which obviously tend to be limited throughout the year. Debates should also be shorter, and with the introduction of mandatory training, more meaningful, with proper focus on material planning considerations. It's possible as well that fewer applications being subject to the scrutiny of members will also lead to a higher success rate for applicants in terms of positive planning outcomes, though I think it's fair to say that local residents, particularly those who are keen to resist increased development in their area, are possibly unlikely to welcome the reduction in democratic oversight by members and the loss of opportunities to try and persuade members through appearances at committee. With better quality decision making, there should in theory also be a reduced risk to local authorities of appeals and legal challenges, or I would say at least successful appeals and challenges. However, local authorities will need to be vigilant in enforcing the mandatory training requirements of members and ensuring they keep an up-to-date record of certified members published to avoid new procedural and other related challenges. Next slide, please, Nona. So to conclude that whistle-stop tour then, I think the changes to the planning process proposed by the bill are a solid start by the government at seeking to increase the rate of development. And it will certainly be interesting to see how the bill is built on through regulations. I think we can expect to see further interventions by the government in this area. For example, we already know it's looking at reducing the role of statutory consultees in the decision-making process. It will also be interesting from my point of view, and I'm sure others are keen as well, to see if the government takes any steps to address the issue of delay post the grant of planning permission, which I think remains an obstacle. The changes introduced by the bill will hopefully accelerate the rate of development consents, but not necessarily developments being actually built and ready for occupation. Whilst developers obviously can't be compelled to build, there were some helpful provisions in the 2023 Levelling Up and Regeneration Act, which could be used by local authorities to incentivise developers to build quicker, which the government could bring into force. I'd be surprised if the government doesn't go further to unlock development. And on that note, I will pass over to Emily, who is dealing with strategic development strategies and development corporation reforms.
Thanks, Rebecca. That was really interesting and also a good follow-on from Emma's talk. So yeah, I'm going to be talking about the fascinating strategic development strategies and development corporation reforms. And those have been introduced by the bill alongside these other reforms, and we'll look at how those are going to impact local authorities, developers and landowners. So as many of you will know, SDSs are not a new concept. They've previously been explored through structure plans, regional and spatial strategies, and more recently and currently through the London Plan. But Labour's aim is to leverage these SDSs to accelerate growth on a scale beyond local planning, aligning with its broader ambition, as mentioned by Rachel at the beginning, to get Britain building and delivering its 1.5 million homes by the end of the Parliament. Next slide, please, Nona. So Section 47 of the bill introduces SDSs through amendments to the Planning and Compulsory Purchase Act 2004, with the detail to be introduced through subsequent regulations if the bill is brought into force. So whilst we do have some detail in the bill, there are gaps, as you might expect, and the provisions won't be operative until they're brought into force by regulations. So I'm just going to take you through some of the key points of the proposals that we do know. The bill sets out who has responsibility for the preparation of these strategies, and they will need to be prepared by combined authorities, combined county authorities, upper tier county authorities, and unitary authorities. And the government may even establish strategic planning boards where it considers that it's desirable for an SDS to cover multiple principal authorities and wants them to work together. The bill also sets out the mandatory requirements, things that SDSs must include, along with some optional content. So under new section 12D of the PCPA 2004, these SDSs must include a statement of strategic policies for the development and use of land, although this statement can be in any form, along with a reasoned justification for those strategic policies. It will also need to set out the period that the strategy is going to cover, and will need to include policies addressing climate change, mitigation and adaptation, although the exact scope of this remains unclear, as well as consideration of any local nature recovery strategy to ensure environmental priorities are embedded. So it just demonstrates the government's continued intention to promote sort of environmental points through whilst strengthening the planning process. In terms of optional content, SDSs can specify infrastructure of strategic importance to facilitate development or promote economic, social or environmental well-being. It doesn't have to. And they can also include policies on the amount and distribution of housing or of affordable housing if this is considered to be of strategic importance. Just really important to note, though, that SDSs cannot allocate land or sites for development. That remains the subject of the local plan. So we know who has to prepare the plan, and we know what it needs to include. New sections 12E to 12L of the 2004 Act outline the preparation process for an SDS. So the authority must first prepare a timetable for the preparation and submit this to the Secretary of State for approval. Following approval, the authority must then prepare a draft SDS in accordance with its timetable and consult on the same, inviting representations from various entities, including the Secretary of State, counties and district authorities who are affected within the strategy area, and those affected in the adjoining areas, and also any others that the Secretary of State may prescribe through future regulation. In addition, the authority must consider notifying, though doesn't need to notify, voluntary bodies whose activities benefit the whole or part of that strategy area, and bodies which represent the interests of different racial, ethnic or national groups in the strategy area. Also religious groups and those bodies which represent the interests of persons carrying out businesses, but they don't have to notify them or consult them. A public examination will then follow, where an independent examiner will consider key matters and prepare a report for the authority. Notably, it's the examiner who chooses the matters to be examined, and while others may be invited to participate, only the strategic authority is guaranteed participation in the process. There is no automatic right to be heard at the examination. Following that examination, the examiner will produce the report for the authority, and the draft SDS, assuming the authority wants to take it forward, is then submitted to the Secretary of State. Before doing so, the authority must consider the recommendations made by the examiner and whether to include these in their strategy. If they decide not to take into account recommendations, they must explain this to the Secretary of State when they submit the strategy. The Secretary of State has 6 weeks or longer if they direct to approve the spatial development strategy or require modifications. But note that they can only require modifications to address inconsistencies with national policies, or if they consider that the SDS would cause a detriment to the interests of areas outside of the strategy area. So the modifications that can be requested are limited. If the SDS is approved by the Secretary of State, it will then become operative once adopted and will form part of the development plan. The SDS must be reviewed periodically, although there's no set timescale, and there is the potential for alterations to be made as needed. Any alterations would need to be made following the same process as we set out before, so preparation and examination, approval, and then adoption. So what do we think the impact is going to be on local authorities from the introduction of SDSs? Well, firstly, local plans will need to be in general conformity with the SDS as they form parts of the development plan. And local planning authorities are therefore going to need to ensure that the local policies and site allocations in their local plan align with the strategic objectives of the SDS. And that limits the flexibility for planning authorities to tailor their local plans to their area. Secondly, as I said, once adopted, the SDS will form part of the development plan, and so planning authorities will need to determine applications in accordance with them, unless there are material considerations indicating otherwise. So this strengthens the influence of the SDS and may reduce local authority discretion in decision making. But it's also another layer of policy, yet another layer of policy, for planning authorities to have to consider when determining applications. And local authorities at all levels will need to engage with the preparation, review and monitoring of these SDSs. And that adds obviously a further burden on already overstretched local authorities. And I don't know necessarily whether any of the uplift in fees will cover any of that work that would need to be done as part of any engagement with that process. For developers and landowners, the introduction of SDSs will have will provide a clear strategic framework for land use and infrastructure across wider areas, and that reduces uncertainty, which could be caused by inconsistent local policies. They could also, are aimed to facilitate large-scale strategic developments by identifying priority areas for growth and infrastructure. So developers working on schemes that span multiple local authority areas are likely to benefit from this approach. However, developers will now have to navigate a two-tier policy framework, and they'll need to engage with two levels of policy: SDSs at the strategic level and local plans at the site-specific level. So this just seems to introduce more complexity and increase the risk of delays where inconsistencies arise, and we don't yet have clarity on how those inconsistencies will be resolved. Finally, there will be reduced scope for challenging decisions for developers. Since SDSs will form part of the development plan, there'll be less scope to challenge those strategic priorities if they don't align with developers' proposals. Just to note as well, before we move on quickly, that the Secretary of State has significant powers to intervene where a strategic planning authority is failing, and that includes taking over the preparation of an SDS, making alterations to an existing one, or directing the adoption, withdrawal or modification of an SDS. So SDSs do represent a significant shift in the strategic planning landscape, with implications for both landowners and local authorities, but it's difficult yet to really understand how they're going to practically impact until we have more detail on the substance and begin to see how these really interact with local plans and with national policy. But clearly local authorities are going to face increased obligations, and developers, although they'll benefit from greater certainty, now may encounter increased complexity in navigating a dual policy framework. So staying ahead of these developments is going to be critical for all stakeholders. So I'm just going to move quickly on now to development corporation reforms, and these are set out in section 79 to 82 of part 4 of the bill. As with spatial development strategies, these are not new concepts. Current legislation already provides for 5 types of different development corporation, and each model has different powers, remits and objectives. So the government's view is that there are limitations on the powers available to development corporations, and that the different models don't sit well with the needs of modern day developments, which is probably not an unfair characterization. So what reforms have they proposed? Under Section 79, development corporations will be allowed to deliver urban extensions, as opposed to simply establishing brand new settlements. They will also be able to develop both greenfield and brownfield sites simultaneously. So urban extensions are probably more appropriate forms of development than establishing a new settlement, given the existing public transport and other necessary infrastructure that exists where you have an urban town already. Development corporations will also be able to establish more than one town if doing so would facilitate efficient development, and it could encourage cross-subsidisation between the towns. So through the bill, the government is looking to create a clearer, more flexible and robust framework for the operation of development corporations to support development and regeneration. For example, through Section 80, the bill, it aims to correct inconsistencies in the legislative framework concerning development corporation objectives. so that all types of development cooperation must aim to contribute to sustainable development and climate change mitigation and adaptation. That's just something that's missing from some types of development cooperation currently. Section 81 aims to standardise the infrastructure that development corporations can provide. It also adds heat networks to the list of such infrastructure and removes restrictions on the provision of railways, light railway and tramways. And then finally, under Section 82, that should say, not Section 81, a duty will also be placed on relevant local transport authorities to cooperate with development corporations and to have regard to plans published by a development corporation where relevant to the exercise of their functions. So in order to encourage this, the Secretary of State is given the power to give directions as to that cooperation and ultimately to transfer specific transport powers where this duty is not fulfilled. This aims to ensure that obviously development corporations are supported in their plans rather than facing resistance. Next slide, please. The requirement to cooperate on transport authorities removes local authority autonomy over transport planning and infrastructure delivery, and the provision allowing development corporations to deliver urban extensions could see local authorities lose some control over major urban extensions. The requirement to cooperate could also require additional resources, again from already overstretched authorities. For developers, development corporations could provide cross-subsidy and the opportunity to deliver urban extensions and develop greenfield and brownfield opens up larger scale opportunities. This approach could encourage the delivery of more complex, larger scale schemes with reduced financial risk, and developers may also see faster decision making where the Secretary of State transfers powers. That's all from me on development corporations. Thanks.
Thanks very much, Emily. Excellent. So this next section is about part 3 of the bill, which deals with nature recovery. Now, the government says in its background information that another reason for delay in housing delivery is the way in which environmental mitigation is delivered in a piecemeal fashion, rather than looking at things more strategically. As I'm sure most of you will know, there are at least 4 potential strands of environmental legislation that may come into play when dealing with a planning application. There's biodiversity net gain, environmental impact assessment, species licensing, and the habitats regulations. BNG has, of course, been brought in recently, and the environmental impact assessment regime is still set to be replaced at some point by environmental outcome reports. Now, the main thrust of the nature recovery provisions in the bill is to address issues arising from the habitats regulations, and in particular the delays, costs, and potentially the blockers that arise where likely significant effects of a development on a European site or species can't be ruled out, leading to a development-specific appropriate assessment having to be carried out, and potentially a block on the development if the assessment concludes that a significant effect on the integrity of the European site will result. These are the issues that we have seen as a result of nutrient neutrality, for example. The Part 3 provisions also deal with species licensing, as you'll hear. So I'm going to hand over now to James, our current trainee, who will provide a brief outline of the current landscape and the reason the government has decided that these reforms are required. Thank you, James.
Thank you, Alistair. And good afternoon, everybody. So in all of the news coverage and press releases, etc., and indeed in our session this afternoon, the 2 big targets in relation to this bill, which you've heard about, are the 1.5 million homes to be delivered this Parliament and the 150 major infrastructure projects which the government is hoping to consent. But when considering nature recovery, I think a really important piece of the current landscape are the legally binding targets under the Environment Act 2021, which have been set out in legislation. And Two of these targets concern nature recovery and biodiversity, and those targets were to increase species abundance by 2030 and to create or restore 500,000 hectares of wildlife-rich habitat by 2042. Now, some might say that the government faces quite a challenge in reconciling these potentially competing targets with the purposes of this bill, which is, of course, more development and achieving the targets of further consents. The Environment Act 2021, added to what, as Alistair has already said, has become a really rich tapestry of environmental legislation, which has been woven into the planning regime in recent decades. So there is, of course, biodiversity net gain, which came in February 2024. All planning applications under Part 3 of the 1990 Act, except those which are exempt, are subject to the mandatory BNG condition. And this isn't something which the bill touches on, but it is important context. Under the Wildlife and Countryside Act 1981, local planning authorities have a general overarching duty to take reasonable steps to further the conservation and enhancement of sites of special scientific interest. Under this act, there is also quite a complex licensing regime for certain types of prescribed activities which disturb wildlife. So, for example, if a developer wanted to remove a protected species like a great crested newt from a potential housing development site and take it to an alternative location, they would need a license under that act. And of course, certain major developments also require environmental impact assessment at the moment to prevent, reduce, or offset the significant adverse environmental effects of those projects. Crucially for this bill, there are also the habitat regulations, which place statutory duties on development in special areas of conservation and sites of special scientific interest. And as Alistair mentioned, this requires a good deal of assessment and seeking to mitigate those effects. I think what we all know is what this patchwork of legislation means in practice is that environmental obligations are typically discharged on a project by project basis, and the question of whether there is sufficient mitigation in relation to a project's impacts could well be the determining factor in a planning application. Very quickly after Keir Starmer stepped into number 10 Downing Street, the new government made clear its intention for reform in this area. On the 20th of July last year, which was just 3 days after the state opening of Parliament, the government wrote an open letter to nature conservation organisations expressing the government's view that reform is required. As you can see on screen here, in that letter they said that the status quo is not working, that environmental assessments and case-by-case negotiations of mitigation and compensation measures often slow down the delivery of much needed housing and infrastructure. Meanwhile, the condition of our environment has declined over a sustained period. The government described this as a lose-lose situation. Since that letter, there has been an increasing political focus on blockers and NIMBYism, including the news story about the now infamous bat shed, which was included for HS2. And in the autumn, the government ran a consultation promising significant changes to the way that nature recovery will be approached in the planning system moving forward. The bill is very much the outcome of that consultation. And I will now hand over to Alistair, who is going to outline the provisions of the bill as they apply to nature recovery.
Thanks very much, James, for setting the scene. So under Part 3, there are two new key concepts which are being introduced. The first is the Environmental Delivery Plan, and the second is the Nature Restoration Levy. In simple terms, the principle of the reforms is that Natural England will be given powers to prepare environmental development plans, which I'll shorthand to EDPs, if you don't mind, which identify environmental features in a specific area and how to address the impacts of development on those features. Now, rather than conducting a project-specific assessment when coming forward with a development, the bill provides that developers will be able to pay a nature restoration levy instead, with the levy proceeds being used by Natural England to implement the measures that they set out in their EDP. So the next slide, please, Nona. Clauses 48 to 50 of the bill set out what environmental development plans should contain. It's first worth getting to know what EDPs are intended to protect. The Act uses the term environmental features, and environmental features can be either a protected feature of a European site, so a special area of conservation or a special protection area, or an SSSI or a Ramsar site, or an environmental feature could be a protected species protected by the Habitats Regulations, the Wildlife and Countryside Act, or they could be badgers protected under the Badgers Act. Environmental development plans will be prepared by Natural England in draft, and then they'll be made by the Secretary of State. They must include a number of things, and I'll explain some of the more important ones now. First, the plan must describe the kind of development to which the EDP applies and include a map showing the area within which it must be carried out if it is to be caught by the EDP. It must also describe any kind of development that's excluded, for example, development which has such an impact that it should not be caught and attract the benefits of the EDP provisions. Secondly, the EDP must specify the maximum amount of development to which the EDP applies. So, for example, this could be by reference to numbers of buildings or units of a particular type. So, for example, the plan could say that once X hundred houses have been granted planning permission, the EDP no longer has effect on any more planning applications for housing after that. And it's back to the habitats and species licensing regime for developers who want to build more houses afterwards. Thirdly, the EDP must describe the environmental features that are likely to be negatively affected by the development of the type to which the EDP applies. And I've already spoken about what environmental features means. Fourthly, the plan must identify the environmental impacts in play. In other words, the ways in which the negative effects on the environmental features are likely to be caused by the type of development in question. And fifthly, the plan must set out the conservation measures, another new term, to be taken by or on behalf of Natural England to address the environmental impacts and to contribute to an overall improvement to the conservation status of the environmental feature in question. Now, the word overall, which I emphasised, is important here because Natural England is allowed to set out conservation measures which seek to improve the conservation status of the same type of environmental feature affected by the development, even if the feature to be improved is elsewhere. So, for example, if a development in Devon has an effect on some newts, the conservation measure might, in theory, improve things for newts in Hampshire. It's important to note that clause 50 subsection 7 says that one of the types of conservation measure that may be taken by Natural England is that it can require the planning, is that it can require Natural England itself to request the local planning authority to impose a planning condition on any application for development. The explanatory notes to the bill give a couple of examples of this. For example, a condition about standards of water efficiency might be requested where water is scarce, or there might be a condition about the position and timing of outdoor lighting if there are bats involved. The local planning authority retains discretion as to whether to impose the condition that's been requested by Natural England under clause 75. But under clause 75, there is a requirement for local planning authorities to cooperate with Natural England, and the explanatory notes say that this in turn creates a presumption in favour of conditions requested by Natural England being imposed. The last feature of plans that EDPs that I'll mention is that they must set out how much the conservation measures are likely to cost, and there must be a charging schedule attached to the plan, setting out how much nature restoration levy will be needed to be paid by developers for each kind of development. EDPs will last for a maximum of 10 years, and Natural England will be responsible for producing a monitoring report at the midpoint and endpoint. When preparing an EDP, Natural England must have regard to the relevant development plans which are covered by its EDP, and must have regard to any environmental improvement plan and other plans or strategies it considers to be relevant. Natural England will have to consult on each draft EDP, and consultees must include local planning authorities in each case. There's an interesting power for the Secretary of State to require public authorities to respond to the consultation. The duty on local planning authorities and others to cooperate, which I mentioned just now, also extend to helping with the preparation and implementation of the EDP. As mentioned at the beginning, the Secretary of State is the person who makes the final version of the EDP, and before doing so, they'll need to be satisfied that the conservation measures are likely to be sufficient to outweigh the negative effect caused by the environmental impact of development on the conservation status of each identified environmental feature. That's in clause 55, and it's called the overall improvement test in the bill. Finally, on EDPs, there's a statutory challenge period of 6 weeks, and there are provisions allowing for the amendment and revocation of EDPs. And if we could have the next slide, please, Nona. And I'll now turn to the second new concept, which I mentioned at the beginning, which is the nature restoration levy. So if there's a development to which an environmental development plan applies, then before the development is commenced, the developer can request to pay the nature restoration levy. This is in clause 61 of the bill. If Natural England or another designated delivery body agrees to this request, the developer must pay the levy. An EDP can also provide that payment of the levy is mandatory for certain kinds of development and certain kinds of environmental impact. So what does the developer get in return for paying the levy? Schedule 4 to the bill sets out how existing conservation legislation will be applied so as to excuse the developer from having to comply with environmental obligations which it would otherwise have to. For example, habitats regulation assessment or species license applications. It's important to note that this won't necessarily mean the developer would avoid a habitats regulation assessment completely. An example is given in the explanatory notes to the bill. If a development has an impact both on, say, nutrient levels in water and on recreational disturbance to birds, and the levy is paid only in respect of the effect of nutrients, then the habitats regulation process will still apply as respects the recreational disturbance, because no levy's been paid in respect of it. On species licenses, the effect of the bill is that rather than the developer having to apply for one, the license will be deemed to have been granted subject to any conditions which can be specified by Natural England in the EDP. Further detail on how the levy will operate in practice and how it will be enforced has been deferred to secondary legislation, but it's worth noting that the obligation to pay it will run with the land, and that regulations may require bodies such as local planning authorities to collect the levy and might also impose planning conditions on certain kinds of development requiring the levy to be paid, which is a bit similar to the BNG legislation, as you know. So that's it on the levy, and it's back to James with a few takeaways from the whole subject.
Yeah, so this is this is our final slide on nature recovery, and I think there are just a few kind of concluding thoughts that we wanted to share about the bill on this topic. And I think the first point is quite a simple one, and it's essentially how long will this take to implement? The government have these really ambitious targets for delivering a certain amount of development this Parliament, but it strikes us as quite unlikely that the full regime for nature recovery, as Alistair has just outlined, will all be in force in the near future. given EDPs are to some extent geographically constrained, there are questions regarding whether the entire country will be moving to this model at exactly the same time. And of course, the bill has to get through Parliament still. There will need to be secondary legislation. And importantly, I think there's going to be a huge amount of work for Natural England and or other delivery bodies to produce and review EDPs, and then to begin collecting payments and eventually begin implementing the conservation measures which are included. If the implementation isn't well managed and well funded, we may all find ourselves reminded of the rollout of the community infrastructure levy, for example, which came forward slowly and sometimes without consistency between regions. The government has also said that in due course, it will seek to support this regime by bringing forward proposals on environmental outcome reports, the streamlined replacement for environmental impact assessments, which were included in the Levelling Up and Regeneration Act 2023, but were not implemented by the previous government. Knitting together all of these very ambitious proposals in this space is certainly going to take time, and it will be really interesting to see whether the time that it takes means that this actually may not necessarily have an impact on those targets which are specific to this Parliament. Alistair, I believe you also had a couple of concluding thoughts before we finish.
Yep, that's right, James. Just a couple of points really on the forthcoming process in Parliament and on funding for Natural England to actually implement all this. So the bill, as Rachel said, is still early on in its journey through Parliament and had its second reading on the 24th of March. So there's still plenty of scope for changes to the bill. And I think that Part 3 on nature recovery is likely to be one of the sections that attracts the most interest. So on 12th of March, the Wildlife Trusts published a parliamentary briefing paper which described the bill's approach to nature recovery as disappointing and proposed additional safeguards for nature recovery, including more rigorous requirements for the approval of environmental delivery plans by the Secretary of State and additional measures such as a new wild belt land use designation. Especially in the context of the wider NIMBYs political debate, it'll be interesting to see whether stakeholder views such as these have any impact and whether any amendments are made to the bill addressing the nature lobby's concerns. Don't hold your breath on that. There's a big government majority, but the Lords do occasionally secure changes for the environmental lobby when the bill gets to their house. And then the other key issue, which has featured prominently in early commentary on the bill, has been resourcing for Natural England, as you would expect, who, as you've heard, will play a huge fundamental role in the new system. An initial £14 million has been allocated by government to the Nature Restoration Fund, but there must be questions as to whether there'll be enough to resource Natural England adequately and if there'll be enough people suitably qualified to carry out all the activities that are going to be required under Part 3. So ultimately, the success of these proposals will come down to whether they can be quickly and effectively implemented, and resourcing is likely to be a determining factor. So that's that end of that section. I'm going to hand back to Emily now for the last part, I think, of the talk. But before I do that, I'm going to embarrass her by saying that yesterday Emily was promoted to be a partner at Sharp Richard, and it fills me with great pleasure because she's been a member of my team since she qualified. So I can see she's going red. And the second point I'd like to make is that she's actually standing in at very, very short notice to do this particular section. So very much appreciated and putting her partnership skills to the test from day 2.
Oh, thanks, Alistair. And thank you to everyone. I can see lots of hands appearing on the screen, which is lovely. And yes, has made me a little bit embarrassed. But anyway, yes, well done to all of you who have managed to stick with us over the last hour or so. I promise I won't take up too much of your time. I'm going to talk about Part 5 of the bill, which contains the reforms to the CPO process and powers. In its guide to the bill, the government sort of says that it recognises the importance of making effective use of land, and it's keen for authorities to make greater use of their compulsory purchase powers to support the delivery of housing growth and regeneration. So once again, we're talking about what can the government do here? What's the government doing to unlock housing and get Britain building? One thing to note at the outset is that these changes are fiddly. The CPO legislation, as I'm sure you're all aware, is vast, and there are various pieces of legislation dealing with different parts of the process and different types of compensation and payment. That means that the bill is fiddly, and how it changes, it makes changes, and there's lots of detail, far too much detail for me to go into today, especially given how long you've all been sat patiently listening. It's worth noting that the Law Commission has just finished consulting again on wholesale changes to the CPO process. That consultation closed on Monday, so hopefully some of you were able to make representations as part of that. It's not the first time the Law Commission has consulted on CPO reform, but let's see if it's the one that makes the changes. So, next slide, please, Nona. As I said, the bill makes various reforms to the CPO regime. Lots of these are process driven, and those are reforms 1 to 5 on the screen, and the final is more substantive. But let's have a look in some more detail. So number 1 is electronic service of notices under section 83. So the legislation establishes a framework for service for notices and other documents to be served electronically. This is undoubtedly a sensible change and just simply brings sort of notice provisions for CPO in line with the digital world in which we live. Notices and documents can be sent via email or uploaded to an agreed upon website, provided the recipient has consented in writing to receive them in that way. So that's important, obviously, that the recipients agreed, protecting those who don't like to work digitally and making sure that people can still take part in the process if they don't have sort of a digital footprint. These provisions apply to individuals, acquiring authorities, confirming authorities, inspectors, local authorities, and statutory undertakers. But note that it doesn't cover communications to the High Court or Upper Tribunal. They also don't apply to CPO orders that have been initiated before the law took effect. Reform 2 deals with newspaper notices. So Section 84 amends the Acquisition of Land Act 1981 to simplify the required content of newspaper notices. Acquiring authorities and ministers can now meet the requirement to describe land by briefly identifying, for example, by a postal address, instead of providing a detailed description. And this applies both to notices of a CPO before its confirmation and notices after confirmation. Not much to say on that one. Reform 3, under this section 85, section 14A of the Acquisition of Land Act 1981 is amended, and this section governs how an acquiring authority can confirm a compulsory purchase order where it's been given notice to do so by the confirming authority. So under current legislation, the acquiring authority can only confirm a CPO if it can be confirmed without modification. However, the provisions in the bill will allow the acquiring authority to confirm the order with certain modifications. There are only certain types of permitted modifications, but those are an additional interest in land being added with the interest holder's consent, an interest in land being removed, part of an interest being removed with the landowner's consent or the interest holder's consent, or where the modification doesn't affect any interest in land. And where the acquiring authority does confirm the order with modifications, it needs to provide a copy of the modified order and certify that those are the only changes. So this obviously provides more flexibility to acquiring authorities to this obviously provides more flexibility, but it'll be interesting to see if this is actually taken forward, and if this is taken forward, how much it's used by acquiring authorities and what the most common reason for its use is. Is it to deal with sort of substantive changes or just kind of minor administrative errors maybe that were made before the CPO was submitted? Reforms 4 and 5 both deal with changes to the process for general vesting declarations. So first we have an expedited process under section 86. This change will allow land to vest in an acquiring authority in less than the usual 3 months in certain circumstances. If those circumstances apply, the land can vest after 6 weeks. So the process can only apply where land is unoccupied, and that doesn't mean that's not met, sorry, where land is being used by unauthorized persons. It's got to be actually unoccupied. It can also be used where the land is in disrepair, neglected, contaminated, or a risk to health and safety, making it unfit for ordinary use. If it includes a dwelling, it must be unfit for human habitation under the Landlord and Tenant Act 1985. And finally, the expedited process can be used where there's no identifiable interest holder or none can be found. So if the land meets that criteria, then the acquiring authority can use the expedited process. It gives notice that it's using that process, and affected persons have 4 weeks from the date of the executed GVD to make representations as to whether that process is appropriate. The authority has to respond within 7 days, and if it later finds that the expedited process shouldn't have applied, it has to amend the declaration and extend the vesting period to at least 3 months. No, it doesn't have to go back to the beginning, it just extends the period which it gave originally. And if the expedited process is used, notices served under section 6, which are served once the GVD is made, must include the information, including a statement why the expedited process applies and that the right to challenge exists, etc. Under section 87, a mechanism was also introduced for advancing the vesting date by agreement between the acquiring authority and the landowner. So the two can agree in writing to vest the land before the vesting date, but it cannot be earlier than the latest date for challenging the CPO. If that agreement is in place, the legal effect of vesting takes effect on the new earlier date, not the date necessarily in the notices. And note that the landowner loses their right to serve a counter notice requesting the acquisition of additional land. So this means that landowners who prefer an earlier vesting date, which might mean receiving compensation sooner, can now negotiate this with the acquiring authority, and it could see a reduction in delays in the process. I think, though, it's going to be interesting to see how much of an impact this is going to have practically. I mean, the difference between 3 months and 6 weeks in the grand scheme of a CPO is not huge. That process can take years and years. So to talk about essentially a less 6 weeks doesn't really seem like a lot. And the process can only be followed in those limited circumstances that I already outlined. So in particular, where a large area is needed, for a linear scheme or even a huge estate regeneration, plots are likely to be in a variety of different states. And so being able to reduce the time limit for vesting some land isn't necessarily going to result in accelerating the scheme overall. So it's an interesting change, but I'm not sure it necessarily is going to go as far as it might be, sort of the headline might suggest. And the final reforms I want to talk about are just the more substantive ones. These are changes to various sort of compensation payments and other payments arising from CPOs. So sections 88 and 89 make adjustments to payments arising for basic and occupiers' loss payments under Part 3 of the Land Compensation Act of 1973. So basic loss payment in England is now the lower of 2.5% of the interest value, or 25k. And for agricultural land and other types of land, the loss payments have also changed and are capped at 75k. I will leave the detail of that to an article. No one needs me to hear me go through all of that right now. Under section 89, home loss payments will not be payable if the person displaced from a dwelling failed to comply with a notice served on them in relation to that land, including notices under section 215 of the TCPA, so that deals with proper maintenance of land, or a repairs notice under the Planning, Listed Buildings and Conservation Areas Act 1990. So those changes just kind of seek to clarify the amount of payment, and also ensure that payments aren't being made where homeowners aren't complying with certain notices that have been served on them. The final point we want to talk about today was hope value. And the government made quite a lot of this in its sort of explanatory memorandum and to the bill, and in sort of the press releases about the bill. But it would be interesting to see whether this sort of does really, again, substantively what it seems to suggest. So under section 91, the bill makes amendments relating to section 14A of the Land Compensation Act 1961. As a reminder, section 14A directions were introduced under LURA, and they mean that where an order is confirmed with a section 14A direction, when assessing the value of the land, it's assumed that no planning permission would be granted for development on that land, essentially meaning that compensation will not include the value attributed to appropriate alternative development or the prospect of planning permission being granted, which has greater value than the existing use. So it limits the payments that are due, the compensation payments due when land is CPO'd. Section 14A directions can only be used for certain types of CPO. And section 91(3) of the bill extends those to CPOs made on behalf of parish or community councils to facilitate affordable or social housing provision under section 125 of the Local Government Act 1972. The bill also makes adjustments to the Land Compensation Act to clarify that market value for home loss payments includes scenarios where compensation is assessed in accordance with section 14A, particularly for cases where planning permission prospects are ignored. So these amendments are important for aligning compensation assessments across different sections of the legislation. As I mentioned at the beginning, the legislation is sort of all over the place, really. But it's important, I think, to keep in mind that these provisions already exist, and it remains to be seen how far this extension of this power to section 125 CPOs will make a practical impact. I, for one, don't know how many CPOs are made using section 125 powers on an annual or regular basis. I don't know if anyone does. And maybe it's those aren't made because there's no longer this process doesn't currently exist, and maybe this will help, but let's see. So I think, just in summary, the changes to the CPO regime are quite extensive. They're quite detailed and nuanced, but the practical impact they have, the practical impact that they'll have across a process which is lengthy, cumbersome, and obviously raises issues of human rights and things like that, is yet to be seen. It certainly feels to me that changes might be needed on a more wholesale basis. And so it'll be interesting to see what comes out of the government's consultation. But that is it from me, and I think from the team in general, and I'll pass back to Rachel.
Thank you, Emily. Yes. So there's just a couple of things, I think, Nona, before that slide. If you could just couple more slides. Just to conclude then, thank you very much to my colleagues, all very interesting. There's a lot in there. Key themes to bring out from all of the talks are it's critical to the economic growth agenda of the government, critical to house building, the bill, critical to fast tracking major infrastructure projects. It's key to a clean and secure energy supply for the country. And as Angela Rayner said on the second reading in Parliament, it is hugely ambitious. It is part of, as I said at the beginning, of the government planning reforms more generally. We've obviously had a published MPPF. We're promised a further MPPF shake-up in the spring, so any time now. We have the New Towns programme announcement that is due again in the spring. So there's lots of reform there. It is building this bill on current legislation to some extent, so not entirely new concepts. It's part of this planning reform looking at holistic, well-planned and designed development. And it is, as Angela Rayner has said, hugely ambitious, and it is all a challenge. Where do you put new development to ensure it's in the right location, sustainable, and balances with, as we've heard about today, the natural environment for one, flooding, so many issues to consider in the sense of new development. And just to round off on all of this, and it's just more of a personal thought, the most successful new development is where there's been engagement and collaboration with all the relevant stakeholders. As we've heard today, there's lobby groups, there's statutory bodies, local authorities, the development industry and house builders. We all have a part to play here in supporting this government, the government ambitions and these planning reforms. So we're all key to it. And when we get down to legislation, as Rebecca mentioned in her talk, that has snazzy a number and ZZZ, maybe there is a need at some point for consolidation of the planning legislation, so you don't end up with so many snazzy sections to the existing legislation and acts. I'm looking at the Q&A and the chat, and I can't see that we have any questions, but we can now open up to questions if anyone has any. Oh, I just also must mention another vital member of our team, Nona Abraham, who has supported the team and organised and put this webinar together for us today. We're very grateful, Nona, for your assistance.
Just to say, Rachel, I think, well, at least I can see a few questions in the Q&A tab that have come in over the last 11 minutes or so, just in case we missed them.
Yeah, just very quickly on Molly's question about EDPs. I think the intention is, I may be wrong, but I think the intention is that this new regime is intended effectively to put aside the in a limited way the mitigation hierarchy insofar as it applies to habitats regulations, but not entirely. In relation to badgers, I haven't got the Act in front of me, and I'm not entirely sure what the precise provisions about the Badgers Act are likely to be. But so far as any requirement in the Badgers Act for any license to do anything is concerned, if the levy has been paid in respect of the environmental effect on badgers as a species, then my understanding is that any such license, like I mentioned in the talk, would be granted or deemed to have been granted with any conditions imposed in the plan by Natural England. So that's that one. I think there may be one other question in there on SDS.
I come in on Sarah's question. Thanks, Sarah. I mean, I think the answer currently is no. An SDS can't include or identify potential areas for future growth. The bill currently is quite clear that so it says a spatial development strategy must not include anything that's not permitted or required. And it can't specify particular sites. There's nothing in the current bill that sort of suggests that it could include identifying potential areas. So I think that would come in under that. It can't include anything that's not permitted or required, but just one to note that there is provision for the Secretary of State to prescribe further matters that the strategy may or must deal with. So I think this is one of those instances where I'm certainly struggling to understand how SDSs and local plans are going to fit together and what kind of how inconsistencies and things will be dealt with between them. And I think that hopefully is going to come out a bit more in as the bill works its way through, and hopefully in regulations. But the answer at the moment, I think, is no.
If I could just add to that, I think a bit like it works in London with the GLA and the London plan, it will involve that engagement with all the relevant authorities in kind of shaping the spatial development strategy. So in that sense, although it doesn't identify and allocate the land, there is input from those relevant authorities into that plan process itself to hopefully have some influence and shape their areas for future growth. Apologies, I didn't pick up on those questions. Okay, I think that is it. So just thank you very much for everybody for your time and listening to the team today. We have got in the chat that we've got some published articles and there's more to come on the new bill and its proposals. I think that would conclude today's session. So thank you very much.
Rachel, I think someone's put their hand up, so may have a question.
Oh, okay. Sorry.
Hi Rachel, hi Alistair.
Hello.
Hi. Just well, first of all, thank you for the great presentation. It was very informative. I just wanted to second Sue Phillips' question about whether you'd be sending out these slides by email or such.
I think the answer to that is we will. Yeah, I don't see any reason why not. Put it that way. So I think we'll look into that. I'm sure we can, Nikita. So yeah.
Thank you. And I think
Thanks, everyone.
thank you very much.
Thanks, everyone. Bye-bye.